Now, Mr. Garland, Mr. Salaman, who is going to speak?
Good morning, Madam. I'm Paul Garland. I'll be doing the bulk of it, but Mr. Salaman would like to make a few points at the end.
That's fine. Thank you very much. And Mr. Westaway for the respondents. Mr. Westaway, if you're embarrassed by being the only person in the room with a wig, you're very welcome to take it off, or you can keep it on if you like. Yes, Mr. Garland.
This appeal stems from the modification order of Footpath in Wisley. We made representations at the public inquiry, the major part of it which concerned public nuisance and whether the use of horses would have precluded the existing footpath from becoming a bridleway. We made detailed written submissions at that inquiry, and I think they set out quite clearly the points which we thought the inspector should have considered.
Mr. Garland, have we got a plan or a photo which shows us where your home is and where the where the path goes?
Yes, the order route plan.
Page 143.
I've seen one somewhere. There's page 143 is a plan.
Yes, here. Yes, I've got quite a few, actually.
Yeah.
You mean the core bundle you're looking at?
Yes.
If you see on the plan point H,
Yes.
you'll see there's
That's Bayan, is it?
That's it. That's our property there. You can see it's just to the right of H. There's a bungalow with a square around it.
Right. Okay.
And,
And are there any photos of the subway?
Yes.
Yeah. The county council, with the committee report, had a annex of photographs. That's 93, 95.
In the other bundle?
That's in the supplement.
Yes.
There's also a photograph at 130 in the supplementary bundle.
130, yes.
There are further photographs which were taken by Mr. Danny Williams. That's at 178.
Looking at the picture at 130, I can't really see a raised subway and a lower subway.
Ah, well, if you see the bollard,
Yes.
there's a row of bollards going along that line all the way
yes,
through to the end of the tunnel, and to the left of the bollard there is a concrete incline at this sort of angle, and then a raised section there where the headroom's about 6 feet.
Sorry, on the left of those?
To the left of that
Yeah.
bollard, yes.
I see. So it's the right of it, which is the lower.
That's right, yes.
Right, I see.
And so that on the left-hand side of the right-of-way there is the bollard,
Yeah.
and on the right-hand side in the photograph you'll see a concrete pillar.
If we go back to 93, that might help you. You were just showing us those smaller pictures, but 93,
Yes.
there's a row of bollards.
Those bollards, yes, that's on the
From the other side.
Oh, that's the other end.
That's,
Yes, I see.
that's looking at the. That's the same view as on 130. And you can see on the one in 93, the raised up section is above the sort of the first two bollards you can see.
So in photograph 130, we can see a line of bollards going away from the camera.
Yes.
But I think by reference to 93, there would also be just out of camera to the left a couple of other bollards going off to the left.
Yes, there are quite a few bollards. The bollards you see in 130 go along the left-hand side of the right-of-way, but before the entry on this is on the Byfleet side, there's a row of bollards going at right angles to the right-of-way.
Yeah.
And in 130, to the right of the right-of-way, you'll see there's a concrete pillar bridge support. There's a row.
Structural pillars for the.
Yes, there's a row of those, and to the right of those pillars is a broad ditch, a tributary of the River Wey, it's a murky local ditch.
And was it possible at any point for vehicles to get down that part on the right-hand side?
On the where the footpath is.
Yes.
When it was constructed to facilitate Thames
yes.
Water, who had a private right of way
Yes.
through that, and when the side road order was made, the height was fixed in agreement with Thames Water that 2.3 metres was sufficient for their use using small vans. But since then, Thames Water haven't used the right of way for many years, and in fact, in 2010, assisted Mr. Salaman in erecting palisade fencing, completely blocking the entrance of the other end.
Yes.
So it's the present vehicular access is not an issue because it's gated at both ends of the footpath.
Since 2010, there have been no vehicles going through there.
Well, yes, but it's
or
it's
no
before-
motor vehicles.
There were other gates prior to that, my lord, which would have prevented vehicular access as well. In 1995, green gates heavy-duty green gates were erected on either side of the footpath on the Sunway side, and that was to prevent access on the road. And they were locked or intermittent between 95 and 2000, but from 2000 up until 2007, or 2010 rather, they were locked and there was no vehicular access there at all.
Do I understand, and it's not an important point, but just for clarity, could Thames Water use it then? I mean, did they have a specific right to use it?
They had a right of way, yes, my lord, but the only right of way which they used was from the back of their waterworks.
Right.
From there, directly under the subway. They didn't use footpath 566 going past our property. They only used it from the back of their property, the waterworks, which was close to the...
But would they go under the subway?
They would go under the subway. They did for a short time in the late 1990s.
Yes.
From the correspondence, it was seen that when these green gates were put in, I think they were unlocked at one stage, and Thames Water were then consulted about them being locked permanently. And I think from that time they no longer needed.
I see. They had no objection to them being locked.
No. In fact, the palisade fencing, they put it up for their own security after a lot of break-ins and so on. So they virtually abandoned their vehicular rights.
All right. Well, we mustn't ask you to give evidence.
No, I don't.
But it's helpful to look at the photos and
Yeah.
you can see. All right.
I was saying that we were fortunate enough to be able to put in detailed written submissions at the planning inquiry. Which are set out in called bundle 125 to 129. That was in the statement of facts to the High Court claim form. So if I may go back a little bit over the rights of way, or the situation when the side roads order was made. That was the side road order was 1978. The motorway was constructed and completed and opened in December 1983. Woking Council had made representations at the public inquiry that the height should be 3 metres. They carried on making representations, and there was a further letter in 1986 where the Department of Transport said that the heading, the height of 2.3 was sufficient and they wouldn't make any changes. So that was in 1986. At that time, the 2.3 metres, I think, complied with the requirements for pedestrian access, and it also met the private access requirements. At the time, there were no technical design standards in relation to bridleways and horses, although in 1978 and 1979, there were some standards which related to pedestrians and cycles. They were before the inspector, but you'll see from the inspector's decision letter, I don't think very much turned on them, except that when the tunnel was opened, it was compliant with the requirements for pedestrian use. We, in preparing the case for the inquiry, hadn't been aware of these design standards, and it was only really at the very last minute that we became aware of these design standards in 1993, which set out minimum standards for the heights in subways, and we sent a letter to the inspector just before a few days before the inquiry started, with submissions that they should consider these conditions, and that letter is in the core bundle at that's it. 128, 129, and it had that photograph which you've seen at 130. That's
supplementary.
Sorry.
So what was the page?
128.
128.
Thanks.
you see, it sets out there that for a subway with longer than 23 metres, this subway is 41 metres. The height is set at 2.7 metres and the width of 4 metres. And that's the minimum dimensions for an unsegregated subway for pedestrians and cycles.
I'm puzzled by the last paragraph. The width of this section of footpath is given as 2 metres in the Surrey definitive statement.
Yes.
I mean, it may be 2 metres further back when it's passing houses and so on, but
No,
the subway is obviously more than 2 metres.
Yeah,
wide.
The existing definitive statement, where the subway is, before this modification order was made, I'm not sure what the reading was. I think it was 2.5 metres, and the total width was shown as 3 metres. But this order had the effect of extending the width to 5 metres. The other sections of the footpath are different. On the section 5, the footpath is made up of, it's got 3 names. The first part from Wisley Lane is 566, and that has, on the definitive map, that has a width of 8 to 10 feet, with a fence-to-fence width of 20 feet, and those are the widths which apply from Wisley Lane up to the junction with footpath 3. So that is just to the north of the waterworks. Footpath 3 was the original footpath which ran from Wisley Lane between the waterworks and the River Way, and then in 1956, 566 was added as a footpath, and the section of footpath 3 in this order route, which runs from the junction of 566 through the tunnel up to the borough boundary at the cart bridge, which I think is point C on the order route plan. That section, I think, is 8 or 10 feet on the definitive map, and 10 feet after the cart bridge, where it becomes footpath 129, is the borough in Woking. So,
Mr. Garland, you just said something that slightly confused me. I think you said that the effect of the order was to extend the width to 5 metres.
yes,
Under the
subway part.
Under the subway, yeah. How did it affect the width? The order? I thought it was really just showing that it moved from pedestrians only to bicycles.
No,
and
if you look at the council minutes, those
yeah.
are in the supplementary bundle. The committee report is 67 to 91. On page 88, they deal with the width of and it says the existing definitive map statements. It's Byfleet 129, fence to fence is 10 feet. Wisley 3.6 metres, fence to fence with a surface of 2 metres. That's referring to the underpass.
Right.
So the pre-existing width was 3.6 fence to fence with a surface of 2 metres, and the effect of the modification order was to extend the whole thing to 5 metres.
Right.
What is the actual width of the footpath underneath the subway?
Well, the used part of it is probably about the 2 metres. there's a rough part, and then there's the area to either side of it, as you can see from the photograph. But the 5 metres is the measurement from the bridge supports to the bollards, which you saw in the photograph.
That's that half which is being used, not the upper part. But
That's right. The upper part is nothing to do with it.
Yes. Yeah. Anyhow, it's common ground that the lower part is 5 metres.
Yes. Surrey have made comments about that the upper part's in dispute, but they've accepted that is not.
Yeah.
That's not within this order, and the only public right of way recognised is this lower part.
No.
And there is an area of rough ground. It's not tarmacked on either, about a metre, I suppose, from the bridge supports and where the bollards are. So far as the widths are concerned, the area immediately to the south of the footpath of the M25, that's footpath 3. The width there is 3 feet.
Your case, as I've understood it, is entirely about under the subway, or under the subway.
No, well, we have the issue of this section of footpath 3, which is the 3 feet, actually, is also an issue. We did raise it in that letter in 128. We do point out that section was not wide enough. If you look at paragraph 9 of my letter, that is 129, we are saying that that section of it is too narrow, and that's also supported by letters from Mrs. Cadman and Mr. Lowe, which were read out at the inquiry, and it's also mentioned those were raised in the High Court proceedings.
Well, this is where I think there is a difference between us. My understanding of the High Court case, and certainly the pleadings and arguments in the High Court, was that it's solely related to the subway and the width under the subway. And Mr. Lowe and Miss Cadman, as I explained in the Skeleton argument, their statements, or actually earlier letters, but they were among the material before the inspector, are relied upon now by Mr. Garland and Mr. Salaman to raise certain points. But as I explained, it actually appears, and it seems it may be common ground, that those letters are not referring to the subway. And that's not the argument that was before the High Court, and it's not the argument for which permission to appeal was granted. So it's a new point.
We are concerned, as I understand it, only with whether the use of the path under the subway creates a public nuisance into a really rather. We're not concerned with what goes on in the open air, so to speak, the other parts of the footpath. If you're going to show us a letter which you say is helpful on the question of public nuisance under the subway, by all means do, and Mr. Westaway may make submissions later that you're misinterpreting the letter, but we're not, as I understand it here, to decide whether the path as it goes along in the open air, for example, outside your home, is too narrow to be satisfactory.
Well, my lord, so far as those letters are concerned, we'll be submitting that they refer to the whole route.
Yes, all right.
In that sense.
Do you want us to look at them?
Yes, Mr. Gary Lowe's letter is supplementary bundle 109. during all my years, the path in question has always been known as a footpath. I would like you to know I vehemently oppose the potential change of use to allow cycles, horses, as I feel the path is totally unsuitable and it would in fact be totally dangerous to pedestrians. So he's referring to in general to the application for the change of use. And at the last paragraph, I feel very strongly that the footpath in question should remain a footpath. And although it doesn't refer specifically to the subway, he's talking about the footpath and the other letters from Mrs. Cadman, that's at 125 and 126.
Right.
In my opinion, it would be an accident waiting to happen, as this route allows cycles and horses to use it. There's no room for safety to step aside if suddenly confronted with a group of cyclists or horses. And at the start of the letter, she says she's objecting to this change of status of the footpath. I walk this route regularly with my dog, so she's talking about the whole route. My Lord, in these submissions which we made at the inquiry, we set out details of the various cases on nuisance, Matthias, Remington, and also referred to the case of Sheringham.
Yes, do you want us to look at those or your skeleton argument?
Well, my Lord, I was really saying this in briefly to say what we made, and then perhaps when I go on to deal with the way in which the inspector and the judge dealt with it, it may be better to deal with it.
All right.
With it then. But what I would like to look at is these dimensions. I think they're summarised quite well in page 126. The British Horse Society guidelines.
Supplementary or
Supplementary. Sorry.
That's Mrs. Cadman.
Oh, sorry, no, I'm wrong. It's the core bundle.
Right.
Yeah, that's what we're talking about. Yeah, I'm referring to a note of it. Yes. Yeah. The full text of the guidance is also set out in the supplementary. That's at 138 to 143.
Oh yes.
But
Picture of two horses. Can you give us the reference?
Yeah. The whole advice is set out in page 138 to 143. 7 of this.
Is it 142? There's a section on underpasses.
All right. I see. And you'll see there that underpasses, the ideal height is at least 3.7 metres, a minimum of 3.4 metres, preferably higher, and width 5 metres, minimum 3 metres. And it goes on to say that while the society seeks the desirable height for underpasses, in exceptional circumstances, a lower height may be tolerated to retain a crossing of a road or railway, which would be unsafe to cross a grade, and where there is no option to increase the height, such as where the water table is high. The absolute minimum in these circumstances would be only 2 metres. Where a lower height for an underpass is locally agreed as acceptable, readers would be expected to dismount. And it also goes on to say that where a lower height is provided, a mounting block should be provided at either end.
Now, Mr. Garland, can you help me with this?
Yeah.
Suppose that a sign was put up at each end of the underpass saying horse riders dismount and perhaps a mounting block provided. Would that make any difference?
Well, I think if you see from the other guidelines from the Department of Transport, leading a horse is risky as well, and there are minimum standards required there for leading a horse. The minimum distance being 2.7 meters, and so on those guidelines, it's simply not high enough to lead a horse.
But these are only guidelines, aren't they? And they're guidelines in accordance with current standards. And
They are guidelines,
yeah.
yes.
But it can't be the case, can it, that when guidelines change, and they usually change to make things safer and to make things better,
Right.
that invalidates, as it were, earlier rights of way. Well, it can't be the case that you have guidelines from a equine association or whatever, which then renders what has been a right of way no longer a right of way.
Well, it was a right of way for pedestrians.
I'm sorry.
It was a right of way for pedestrians only. There was no bridle way when.
Well, that's the issue in a sense, isn't
Pardon?
it? That's the issue. We have to decide whether.
Yes, that's right. And the question about mounting blocks, there's no room there really. With certainly not on the southern side of it.
Why not? Why couldn't you put a mounting block back onto the bollards? In the photograph you first took us to, which shows the line of bollards going away
from the
camera.
Well, that's not highway land.
That's not what?
That's not highway land. The highway is only where the track is. Where the bollards are is private property.
No, but we're concerned with whether or not, in the absence of mounting blocks or greater height, this amounts to a public nuisance.
Yes.
For that purpose, it doesn't really matter whose land the mounting block is on. What you're suggesting to us is that an ameliorating feature would be the presence of a mounting block. And I can't...
Well,
I think you've just suggested there would be no place for a mounting block, but there would
well,
be.
I'm not suggesting that a mounting block is appropriate. The British Horse Society has said that that there should be, where you have to dismount, there's a requirement for a mounting block.
Well, you say that a dismounted horse is still giving rise to a public
That's
nuisance.
right, yes, and that the height is not sufficient.
Well, it's pretty simple, isn't it? If you're right about that, then no bridleway can ever be created through a subway of less than 3.7 metres in height, at all, in any circumstances.
Well, I don't think they're not saying that, my lord, because
No, but are you saying that?
the British Horse Society are saying that it can be 3.4 metres has been put forward in the design standard.
All right, 3.4. But it is that must be the heart of your argument, isn't it?
Yeah. Well, all these standards say that there can be some variation or consideration of local circumstances. In this case, the 2 metres requirement or possibility, they say, that would require, for them to think that that was safe, it would require mounting blocks. There aren't any, so you're considering whether there is a public nuisance. You have to take into account the fact that there aren't mounting blocks. And would the Department of Transport have intended such a thing?
Well, can I go back to my original question? Would mounting blocks with signs saying horse riders dismount make any difference?
No, my lord.
I think you're saying no. Well, then we come back to the question. If that's right, you say, you may be right, I don't know. You say it's not safe for pedestrians if horses go through this subway, whether they're being led or whether they're being ridden.
Yeah.
Okay. Therefore, and that's because the subway is not high enough for a mounted rider to ride, or maybe even if it were, you would say it would still be dangerous.
That's right.
To pedestrians.
And also not high enough to lead a horse through.
Right. So it must follow that no bridleway can ever be created through a motorway subway of this kind, because it's not, even if it's only used very occasionally by horse riders, you say, it poses a potential danger to pedestrians, whether the horse is being ridden or led. Therefore, it can never be a bridleway. Therefore, cyclists cannot be granted the right of way.
Yes.
And that's the heart of it, really.
Yes. And in fact, that the way you've put it is the way in which the judge in the High Court put our proposition, and that's right.
And it must also be of influence. We're not just talking about is the height times the length. And the fact that pedestrians rarely mentioned with concentrating about the horse. We're never talking about pedestrians going through the tunnel, which is 41 meters long. I mean, my lord, if he was there, I can assure you, you wouldn't want to walk through that tunnel with a horse.
Well, I might well not want to for various reasons, but there we are. Anyway, back to you, Mr. Garland.
Yeah, thank you. Yeah. I mean, the design standards because I'm looking at para 53 of page 126 of the core bundle.
Could you give me the page number again?
126.
Thank you.
The headroom and width requirements of pedestrians are also given to apply to all schemes for the construction and improvements of trunk roads. It said that bridleways are to be incorporated into subways. The minimum headroom should be 3.7, except where suitable facilities to riders who dismount are provided. So if they aren't provided, it's there again, making that point we discussed earlier on. And in para 53, I refer to the later 2005 standards, which sets that, showing that the standards of safety, as with all highway designs, there's a need for a balance of issues of safety and practicality. The advice provides preferred and acceptable minimum values based on the best available evidence. And and these design standards were made under the requirements of the Infrastructure Act to meet the Motorways Authority's duties to protect the safety of road users. So that's why it's our assertion that these standards are safety standards in their own right. And what you had in the with such a shortfall of those standards, we're talking about with the heights about is 2/3 of what the height is. That's so far beneath the what they call minimum standards. Because I mean, they do say that it's for leading a horse, the minimum standard is 2.7 meters, and they point out that leading a horse, horses can be difficult to control if they are being led, and it should be best avoided if it's at all possible.
Can we put this in context? Is there any evidence admissible before this court as to how many pedestrians use this subway per day, or per week, or per month?
No. Right now, there's not many at all because they're frightened of the horses.
No, I don't think so.
No. The only evidence is from the user forms. Well, that's not in the bundle, so I mean,
So we don't have any qualitative or quantitative evidence about how many people might be affected by if a horse were to go through.
Well, no, my lord. But the fact is, though, if a horse goes through, anybody who happens to be there at that time is in danger.
Well, I understand that. Did the inspector have before him, and therefore do we have before us in the bundle of what was before the inspector, any sort of estimate of the usage of this subway, A, by pedestrians, B, by cyclists, and C, by horses, per day, per week, per year?
There would have been a schedule from the user forms, which set out the number of times a year pedestrians had used it.
But your case and the evidence, I think, as you've summarised it in your skeleton, is that horse use is very rare compared to cycles.
Well, that's correct, my lord. But I mean, they have the inspector and the High Court have found that there was horse use. If you look at the committee report,
well, I understand that they found that there was horse use. But
Yeah.
I just wanted to be clear.
even
if we don't have primary evidence, your case is that horse use is very rare compared to cycles.
Well, I think you need to look at the history of this, my lord, because
Well, I'm looking at
the user
paragraph 7
period.
of your skeleton.
Well, yes, my lord, but the user period, which was considered, was 20 years ago. It was 1983 until 1999. It hasn't been possible for horses to use it since 2000 up till now. So there's
Could you say that again? It hasn't been possible?
for horses to use the path.
Why not?
Because of the barriers. Well, if you go through it, my lord, if you work back from now, the council put in kissing gates at either end of the path in 2012. They put in
The green gates.
they put in green gates,
In 85.
which were installed in 1993 to 95, and those gates were not permanently locked, but on and off from 95 to 2000, and that were then permanently locked from 2000 up until 2010.
Yes, and there was evidence that you relied upon that one gentleman said that he had to carry his bike across
Yeah,
or something.
but there's more to it than that, because the bollard, there was a row of bollards on the green gates to the south of the motorway had a series of bollards along the path and at right angles to the footpath, and the issue is whether horses could get through the gaps in those bollards.
But if we look at the photographs that you took us to at the beginning,
Yes.
horses could easily go through.
That's not the bollards we're talking about. Those
No,
are
I
on
know.
the north side.
But the photographs that you showed us, showing the state of the subway, would not prevent horses going through. Would it?
Those are bollards along the side. There's another photograph.
While Mr. Garland's finding the photograph, my understanding is that a horse could ride through the subway, or a rider could ride through a subway on a horse. Now, there's nothing to prevent that happening, but it's correct to observe that use is occasional. Of course, the use that the inspector was relying upon was between 1983 and 1999. I rose to answer, or attempt to answer, a question of Lord Justice Bean on relative use and the frequency of that use. And clearly the use of horses has been used by horses and their riders is a lot more limited than used by cyclists. As far as I know, there's no survey of separate pedestrian use. Clearly there would be pedestrian use because some residents live down there, but there's no suggestion it's particularly extensive. What there is an analysis of the cyclists' use. In 2016, there was some evidence before the Surrey County Council, and that's referred to in the officer's report. The problem with that is it's updated by the time we get to the inquiry for the inspector, and it's really at paras 38 and following of the order decision that the inspector attempts to summarise what was before him in terms of use, including para 40 on frequency of use. No, my lord, that's what the inspector said about what was before him. There was a pack of user evidence forms, some of which were in evidence before the High Court. Not all of them. We didn't think it mattered to put every single one before the High Court. We can certainly dig those out and provide them to this court if that would assist. They attest to use by cyclists, but the way user evidence forms work is they have a little box. So it might well be that someone ticks the box cyclist and also the box pedestrian and also the box motor vehicles. I think some of them did. I don't quite know why, but going back in time, I think some people had using it in motor vehicles.
Thank you. Mr. Westway, can you just give us the page reference for one user evidence form, if we've got one, so that we can just see what it looks like?
I think the only one in the bundle before you is from Mr. Woodruff, so I'll dig that out.
All right.
May I ask you, while you're up on this, at paragraph 40 of the decision, you were just telling us about the frequency. And it says the frequency of the specified use is stated to range from once a year to around once a week. Is that for any particular person, or what? I don't quite understand what that's telling me.
Well, it's rather rough. Some of the user evidence forms would have said once a week. Others, presumably from people who perhaps live a little further away, would have said once a year.
But that would be giving their own evidence.
I had the same question as my lord, but I think I've worked it out, and that's why I want to look at the form. We're not talking about once a year or once a week by anyone, or even by a horse, but it's per person filling in one of the 57 forms.
So I think the only example of a form in evidence before this court today is page 132 of a supplementary bundle.
How many?
supplementary 132 of the supplementary bundle. And it's mine is, as with many of these documents, I hope the court has slightly better versions than I do. But
Terrible copy.
Mine's rather poor. But you can, I think, make out question 3. That distinction on foot, horseback, bicycle, horse and carriage with a motor vehicle.
Oh, right, yes. Okay, a number of times per year. Is it foot, horse, bicycle? Okay. Right, thank you, Mr. Westaway. Back to you, Mr. Garland.
We were talking about these bollards. If the county council did some measurements which were presented to the inspector, that's at 178 of the supplementary bundle. And there's a number of photographs there. At page 180, there's a photograph with Wisley side, Bollard's Gap on eastern side, 85 to 95 centimetres on average. And the photograph under that the gate posts of the green gate posts, which I've been referred to, can be seen there.
Page 180.
180. Yeah.
That was the 1993 to 95, I think you told us they were kept locked.
Yes, that's right. Yeah.
Yes. Right.
They were put in 93 to 95. They were locked between that period, and again locked completely from 2000 onwards. I think they were removed in 2010. The picture above there shows a kissing gate, and that's the kissing gate and the palisade fencing. That's on the south side of the Wisley underpass. That's the kissing gate, which was the subject of the judicial review proceedings, which I referred to earlier, which said that where that gate was, the footpath there was the 3 feet. But we're not particularly concerned with that. The kissing gate has been removed, but the palisade fencing is still there. The gate posts, the green gate posts, can be seen there, and the bollards we're talking about run to the right of that photograph. You can see that there's a dark patch there, which is the gate post. They run at right angles to the path, and also from the gate post up towards the palisade fencing. And you'll see that the county council put the bollard gaps there between 85 and 95 centimetres on average. At the site meeting, those measurements were checked, and the measurement then was 82 centimetres. Yes. So there is an issue over whether horses could get through those gaps. The width of a horse, the British Horse Society state that 1.5 metres is required. It's a criminal offence to place a gate on a bridleway which is less than 1.5 metres. So the inspector in his decision letter referred, it seems that cyclists and horses may have been able to get through those bollards, but I think whatever the rights and wrongs of that is, it's clearly a serious impediment to getting through. 82 centimetres, it was an effective barrier. Yes, 82. Whereas it's 1.5 metres, that's almost half the minimum size. I think a horse needs 1.5 metres. I think the British Horse Society say to walk through. So that may account for the low level of horse use. Of course, if it becomes a bridleway and it's public, it's open. Mr. Westaway referred to there being free access at the moment. That's only recently, since the modification order has been made. The county council very recently removed the actual gates of the kissing gates at either end of the route. So it's open in that sense, and really that is the first time that now that there has been really free access for a very considerable period of time. The Woodruff family, or those who own the stables to the north of the route in Byfleet, were those who have put in the horse user forms. They wrote a letter, which is in the documents, in 2014 to the county council.
So, Mr. Garland, is the essence of your case this? I mean, you'll appreciate that we're not here to hear fresh submissions about whether or not this road ought to have been identified as a bridleway. We're here to determine whether or not there's been an error in the approach below. Yeah. And as I understand it, the error you say is that in the light of the intrinsic nature of this subway, being 41 metres long, the combination of the length and the height, if you have horses there, whether they are being ridden or whether they are being led, they are intrinsically creating a public nuisance, not, as I understand it, because of any obstruction of pedestrians, but because of a potential danger to pedestrians who will also be using that subway. Is that a fair? Is that?
Well, I think there is a question of possible of obstruction, but if a horse goes out of control, then it's in danger and it's an obstruction. But
well, it's got to be an obstruction to part of the public. It can't just be an odd occasion.
No,
that wouldn't help you.
Quite understand. Yeah.
It's essentially the danger point you're focusing on, isn't it?
That's correct.
And you're saying that no sensible inspector could have concluded on the evidence, particularly the evidence from about what space horses need and so on to be ridden under these subways. He couldn't properly have concluded as he did. Is that the heart of that's the heart of your case?
Yes, indeed, Mo.
And my lord, it's also interfering with an existing right for pedestrians, because pedestrians have been using this. My lord said about how many. Well, I've lived there before, Mr. Garland, and just off the top of my head, say it's 20 a day, and some of them are elderly, and they come down and they enjoy not having to negotiate with horses or cyclists. Since this order has been made, one thing I was surprised with, I knew it would have an effect because people are frightened of horses. It's not that they don't love horses, they love horses, but they are frightened. Since this order has taken effect, the impact has been enormous. They just won't come because they're frightened.
Right, now, we've got to be careful, Mr. Salaman. We're not a court receiving evidence. We have to attempt the rather dry legal task of deciding whether the inspector, on the evidence before him, made an error of law. And I don't think what has happened since then can really make a difference. We've also got to focus on the public nuisance issues on which Lord Justice Stuart-Smith gave leave. So I think the history of the green gates and the kissing gates and so on is probably not relevant. You ran an argument about lack of intention to dedicate and so on. That's not before us. We are focusing on the public nuisance.
Yeah. Well, look, the purpose of my referring to the green gates was not to go over the case, but to show that there was limited access, and
Yes.
now those impediments have gone.
Yes.
You could expect a higher usage because it was difficult before. That was the only point.
Yes.
I wasn't trying to go back on those. If I turn now to the inspector's decision letter.
Yes.
And what he made of the representations which we made to him. This is at page 139 of the core bundle.
Yes.
Paragraph 47 states that a number of documents provided post-date the construction of the subway. They're forward-looking documents setting out the design standards for future schemes. The same applies to the British Horse Society guidance. Now, that's all he says about them. And in page 47, he says, for these reasons, I conclude on the balance of probabilities that dedication can be implied. Well, for these reasons, well, there weren't any reasons. All he said is that the evidence supported cyclists and horses had used the claim form. He didn't address whether those design standards had any, whether they'd taken them into account or not. The only explanation he gave was that they post-dated the construction of the subway and they're forward-looking. Now, the only conclusion you can take from that, I would say, was that he thought they weren't relevant and didn't take any notice of them. They didn't apply, they only related to things that happened in the future, and they weren't relevant to the point he had to consider. But he doesn't give any explanation about that at all.
Well, isn't he saying implicitly that if the subway met the standards which were applicable at the time, then that would be really the central evidence, because if they met those standards, one might expect that public standards of that kind would be consistent with allowing
Pedestrians.
For pedestrians, yes, my
For
lord.
pedestrians.
But it was built for those standards, but it says nothing to what if there is a change of use, if bridleway.
Well, it's not. Sorry to interrupt, but I mean it's talking about roads in urban areas publication. It seems to be talking about the kind of standards you need for subways.
No,
I don't think it's focusing on this subway.
No, I'm not talking about. That's irrelevant. That section. The inspector was talking about. There was an argument over whether the 2.3 metres was high enough, and under the 1966 standards, it was, or it appeared to be. But he goes on to say, but that's got nothing to do. On balance, it's got doesn't have any bearing on whether an inference of dedication can arise from occurred once the subway had been built.
In 1966,
Yeah.
were there separate standards for different categories of subway? So pedestrian.
They were mostly pedestrian, but there were various amendments come through. But I mean, it wasn't a major focus of the because when the side roads order was made, it was in May 78, and in 78, 79 further in.
But is
design
this the
standards
position that when this subway was created, sometime between 78 and 83, it did not conflict with any current design standards?
At the time, at the time, for a footpath, my lord.
And a private
when
exit.
Could we just have
But
one
from 78, 79, there was a requirement. It wouldn't have been high enough for pedestrians. But it was signed off and permission was granted for the 2.3 metres. It specifically says in the side roads order, headroom 2.3 metres.
And you've given us the reference to that.
In the side roads order.
Yes. But do we have, either in the original or otherwise, anything which shows that at the time, had it been intended to be for cyclists and horses as well as for pedestrians, 2.3 would have been inadequate?
Well, the 78, 79, at the time it was built for pedestrians, and the argument then was if you wish to add in pedestrians, then you would take, when it was opened in 83, and in 83 it certainly wasn't sufficient for pedestrians.
I just don't want to get confused about this,
Yeah.
which I am rapidly becoming. My question is this: either in 78 or in 83, were there current standards which said that if a subway is to be used for cyclists and or horses, 2.3 is inadequate?
There were no standards for horses until the 93 standards. As my understanding is from the, so far as the pedestrians are concerned, for cyclists it wouldn't have been.
There has never been a time when 2.3 was sufficient for horses. The suggestion is hideous.
Well, I think if one looks at the paragraph 47, I think one has to look at the last sentence of paragraph 45 to see what I believe the inspector's addressing here. Because he's dealing here with a contention that the MOT did not have the capacity to grant bridleway rights because it breached their own design standards.
Yes.
And I think what he's finding is that they wouldn't have breached their own design standards, and therefore...
Well, it was a breach for bridleway standards.
No, it wasn't breaching their own design standards, which was the argument that was being addressed. He's dealt with that point and said, no, it's not in breach. No. When they built it, it was in accordance with their own standards.
Yeah, we weren't challenging that it was that it breached, that it wasn't high enough. We were saying it wasn't high enough for a bridleway.
Mr. Salaman, I'm trying to keep this informal, but we can't have a sort of everybody chipping in as though it was a seminar. Can you leave it to Mr. Garland, prompt him if necessary, and then when he's finished, if you need to add anything, then please do. Mr. Garland.
Yeah. Well, I think it was never part of our case say that the 2.3 metres that did not comply with the requirements then for an underpass with pedestrian.
Mr. Garland, it may not be part of your case or been part of your case, but it certainly, it seems to me, a case which the inspector is there addressing, which was at least made by some objectors, because that's what he seems to be saying in the last sentence of paragraph 45.
Well, in the last paragraph of 45, he's referring to those design standards which we say, and he's saying that it had breached those design standards.
There we are. Yeah.
What he then goes on to say in 48, where it was apparent that above that there was a potential for the subway to have been conformed to the relevant design standards for use by pedestrians and cyclists when it was approved. Well, nonetheless, I do not find on balance that this was an issue on bearing and so on. Well, when it was approved in 78, we're accepting that it would have been high enough for possibly high enough for cycle use, But that wasn't the case by the time it was built, but in 83. And there were no design standards then for horses at all. The first one was in 93. So if you're talking about, you have to factor in that there was no standard for horses, and the horses we were saying you couldn't have used it. It was built as a subway for. It was built as a subway for pedestrians. Now, if the Department of Transport had wanted to make that into a bridleway, then that would have been an improvement, and it would have had to have the higher rights at whatever stage they were decided to do that. See, the inspector said the number of the documents provided post-dated the construction of the subway. They were forward-looking documents setting out the design standards for future schemes. Well, we were saying to him quite clearly that those design standards were safety standards, and he should have, there was evidence that it was a public nuisance. But his comment there, they provide post-date the construction, they are forward-looking. I mean, the only implication you can take from that was he thought they weren't relevant and didn't take account of the horse standards. The British Horse Society, there's things in there like the British Horse Society guidelines say that an average rider of a horse is between 2.55 metres and 3 metres. Well, has he disregarded that fact? It looks like it. That's what he's saying. He just doesn't want to know. But there's nothing, well, the height of a horse has got nothing to do with whether it postdates the motorway. I can see no interpretation that he was addressing or explaining in any way what he'd taken into account and what he hadn't. I don't know if he'd given any heed at all to those standards.
Now, remember that we are focusing on public nuisance aspect of the case.
Yeah.
And if I understand it right, that is the nuisance or danger posed by horses to pedestrians, not with whether a horse rider would
Yes. Well,
have his head knocked off if he went into the subway. And I think the law of public nuisance says that's his problem.
yeah.
The law of public nuisance is concerned by with the danger to
Yeah.
other users, specifically pedestrians, and that takes us to paragraphs 50 and 51 of the inspector's decision.
Yes, ma'am. I think so far as the safety of the horse riders is concerned, that is a consideration for the character of the way, something which may be relevant there, but specifically for public nuisance, yes, we're concerned with the public. If a horse rider is injured in the course of losing control, it's the aspect of that would may have an impact on his ability to control the horse and create greater danger for a member of the public who happened to be in the way. Now, turning to 50 and 51, I mean, he's accepted there in 51 that the granting of higher public rights might constitute a public nuisance to pedestrians. And we have also taken the point here that the way that is written suggests that there has to be an act of public nuisance, whereas we're saying that he has to take into account the likelihood of a public.
And that's on the basis of the guidance?
Yes, my lord.
Because Lord Scott
Yeah.
is actual public nuisance, and you stretch that to risk of public nuisance by reference to the guidance.
Well, perhaps if we can come on to that.
I don't want to take you out of your way. I just want.
Yes, I will address that point. Yes, it's.
But that is that's a fair summary of your position.
Yeah. Yeah.
Can I just ask you, while my lord has taken you to paragraphs 50 and 51, and this may just be a prelude to your consideration of public nuisance. The first sentence of paragraph 51 is, there is lack of evidence to substantiate the objector's claim for designation of the routes of the bridleway will constitute a nuisance. Now, leave aside the argument about whether it's will or may.
Yeah.
It seems to me that life would be quite different, or potentially different, in these two different circumstances. One is that there is a constant stream, or would be a constant stream of pedestrians, socially distanced, of course, and coming in the opposite direction, or indeed the same direction, a constant stream of horses. That's at one extreme end of the other would be where the reality is that a horse and a pedestrian might meet once a week, once a month, once a year. But I don't want to hear evidence from anybody. But at the moment, on the exchange we've had earlier, it seems that there is no real evidence to say where within that spectrum this case may come. Is that a fair observation?
Well, you have the letter from Mrs. Woodruff, who operates these stables, who's essentially complaining that she wanted to take groups of children through the tunnel to. So she hasn't been able to do that because of the. So you have to take into account that we do know there is somebody who has been complaining that they do want to use it. I mean, it's not as if if there was no possibility that a horse was going to be there. If it's a bridleway, it's still open for somebody to come along and try to use it. And if anybody's in the way, I think the real fact here is that the height is just so low.
The height is what?
Just so low at 2.3 metres. And as we've said, it's not really. It sounds superficially, oh, we'll just lead it through, but that's got its problems as well. And, as the guidance has said there, that horses can be difficult. Another aspect there is from the evidence you have from the people who've objected. Many of them are dog walkers, and dogs and horses, dog barking or.
And the letter from Mrs. Woodruff is at page 42. Mrs. Woodruff, 42 to 47 of the supplementary bundle.
Yes. And they also submitted user forms, but they were very poor quality, and I think we discussed it earlier. But page 46, you mentioned about the using the children. And of course, that with the groups of children there's a number of horses going through at a particular time. And the Woodruff thought it is a livery stable, so if it does become open, then there's the possibility that they would use it. The earlier, some of the user forms from the Woodruff did say that they had gone through, ridden through it, having to crouch down onto the horse's neck to get through. And that was also, we've heard evidence of that from Mr. Creswell's, reference to Mrs. Creswell's daughter, Mr. Creswell's daughter having to crouch down.
All right, now we've looked at the paragraphs 50 and 51 of the inspector's decision. Should we then look at what the judge in the planning court said
Yes,
about
I'll come on to
that
that.
topic?
I mean, the main point with 50 and 51 is the absence of reasons,
Yes.
and we don't know what he took account of and what he didn't. The judge's reasons, that's it. He goes through our submissions at page 52 for bundle.
Yes.
And deals with the case law was referred to of Remington. Some mentions there the case of Sheringham. See, in Sheringham, the nuisance was people having to stand out of the way as carts moved by. And it seems to me that's very much a parallel with what we have in this situation.
Only the cat's more controllable.
It's our submission that the judge didn't take proper account of the Sheringham case and of those other the other nuisance cases. In paragraph 44 at page 55, he said there is nothing in the inspector's reasoning in DL 50 and 51 to support the contention that he failed to approach the question on a correct understanding of the law. He goes on to say that it's clear from the first sentence of 52 that the inspector had in mind the physical character of the route. Well, it doesn't really answer the points which had been raised. We don't know what the inspector's reasoning are. All the facts which we set out, which we think the inspector should have relied on, it just doesn't really explain why those, how the inspector dealt with them. He says in paragraph 45, it's clear from the first sentence in DL 51, he approached the question as being one of fact for him to determine on the evidence before him. Well, he didn't go through the evidence. He didn't give reasons for it, and the judge has gone on then to say, oh, well, it's... hasn't met any of the criteria of the Overton Farm case, and he goes then on to consider whether this should be dealt with on Wednesbury principles. We think the judge is wrong there in 46. The judge doesn't really give reasons as to why. He just says the inspector's address the correct question, but again, there's no reasons. In 47, the judge quoted from the submissions which we put to the inspector and sets those facts out with the headroom. Also quotes the evidence which we set out in the submissions that Mr. Williams, the footpath access officer for Surrey, said that it was possible to ride through the tunnel with care. There is no evidence to show what care used or how safe it was. Now, the judge goes on to accept, to say that the judge was that the inspector was entitled to give substantial weight to Mr. Williams' evidence. Mr. Williams didn't give evidence about what he was describing. We don't know who it was that he was observing that you could go through with care. The real issue is it may be physically possible to go through there, but the question is whether it's a public nuisance or not. And the inspector didn't hear any evidence of any expertise from Mr. Williams so far as horses were concerned. We knew that he was a footpath officer. The inspector, the judge relies on the fact that he is a member of the Institute of Public Rights of Way, but that doesn't give any qualification as an expert on what horses may or may not do. There was no evidence before the inquiry or in the High Court about the qualifications for being an institute of public rights of way, and we think that reliance on Mr. Williams' evidence is totally unreasonable.
Well, his evidence was. Would you accept his evidence was admissible?
No, I wouldn't have done.
Not even in the context of an inquiry.
Well, there was no factual basis for him to say it. Well, that's the problem.
Well, why do you say that? He is at the very lowest an experienced officer dealing with questions to do with rights of way. He's been to the site.
Well, it's a question of safety and how well somebody can ride a horse through a low tunnel without causing danger. There was nothing.
As valuable or invaluable as anybody else's assessment, isn't it?
Yes, but not as to say it's an expert. I mean, it's no. It was no different from, say, Mr. Creswell referring to his daughter riding through the tunnel, clinging on his neck because he didn't think it was safe. It's in the same category as that.
That was the only direct evidence the inspector had either way, wasn't it?
Yeah, there was a similar one of the Woodruff user forms. One of them referred to crouching down.
Yes.
That's the only evidence he had of use, and so it's a conjecture.
Well, it seems to me that point goes both ways. First of all, I'm not a planning expert, but I understood that planning inspectors take a fairly broad view of who can give evidence before them.
Yeah.
What weight one attaches to it.
Well, that's exactly the point. Yeah, I mean, I take your point that we have letters from Mrs. Cadman saying it's dangerous, and it's in the same category. That's entirely right. Yeah. I agree with that, my lord. But the judge was saying the judge was saying that great weight should have been put on Mr. Williams' evidence, and that's what we're querying.
Well, weight was a matter for the inspector. Full stop, wasn't it?
Well, if he did, the inspector. Well, the thing is with this, my lord, that the inspector didn't mention Mr. Williams' evidence at all in the decision letter. We mentioned Mr. Williams' evidence in our written submissions and said that this doesn't mean anything. It doesn't show it's safe. But so it was specifically raised with the inspector, but he didn't.
Can I say, why should anybody have any regard for Mr. Williams's evidence? This is a man who took 10 witness statements, only from one side, and took none from the others. It's not good enough, and I will not have it.
Mr.
I'm
Salaman,
not having it.
Mr. Salaman, you should know better than to speak like that in court. We will have an appeal based on whether the inspector went wrong in law, and I'm afraid you can't give evidence, and this is not the court in which you can say that Mr. Williams was a witness who was lying or who was biased or something like that. Now, Mr. Garland, back to you.
I mean, it was said that this is more than just a question of what weight is attached to Mr. Williams' evidence. It's of whether it's a relevant consideration at all, because it's not based on any fact.
Well, I think if we go back to the inspector's decision 51 on page 140, you're saying that, you did say, he didn't give reasons for his finding at paragraph 51, first sentence.
Yeah.
There is a lack of evidence to substantiate the objector's claim that the designation of the route as a bridleway will constitute a nuisance for pedestrians. If the inspector had set out what the judge set out at the judge's paragraph 49 and 50, 51, you'd be in difficulty, wouldn't you?
Well, the fact is, my lord, that he didn't set out those reasons. He didn't give them, and we don't know what it was. The inspector, he said he was entitled reasonably to reach that conclusion. Well, we don't know if he was.
That's a fair response, but it doesn't answer my lord's question. If it had said that, if the report, the inspector's report, had actually referred to the matters referred to by the judge in terms, you wouldn't be able to run this argument, would you?
I don't agree with that, because it was it's whether those are. If you're saying it's just a question of the weight you attach to that evidence, but our argument is that he ignored that evidence.
On what basis do you say that? He refers to it?
Well,
it's before him? Why do you say he ignored it?
Well, he hasn't given any. That's the only implication you can take from it. He said there is a lack of evidence. If he had dealt with the various points, we would have been in a position to know whether there was anything in the headroom and Mr. Williams and so on. But he hadn't done that.
Well, suppose the judge had, sorry, not the judge, the inspector. Suppose the inspector had said, I have the evidence of Mrs. Cadman that she could only ride through the tunnel by crouching down. It's all very difficult. And I have the evidence of Mr. Cresswell that his daughter had a pretty scary experience going through the tunnel, and she had to hang on for dear life to the horse. But that's all the evidence I've had about danger in the tunnel, and I don't think it establishes a public nuisance. Now, suppose the inspector had said that would have been correct as a statement of what evidence he had, wouldn't it?
Yes, but then it's a question of how he deals with it.
All right. Well, can we come on? Can we come on to the question of what constitutes a public nuisance? I think Mr. Westaway will say on the other side that evidence that of one or two incidents of this kind causing danger perhaps to the rider rather than pedestrians, but anyway, evidence of very occasional incidents of this kind is not enough to constitute a public nuisance. Now, what do you say about that?
Well, I say that what we're looking at is if a right of way is granted for a bridle way, it's going to be open for all comers to use. And what you're looking at specifically in the past was when it wasn't a bridle way. There were impediments to get there, but the risk is the same. There will be. You have letters from the Woodruffs that they want to start using it again, and if it's a more abstract thing, surely if horse riders go through that tunnel because of the height, it's dangerous.
Same thing would happen to anyone.
That's the end. That's the beginning and end of your argument, isn't it? I don't mean to say therefore it's wrong. I'm just saying the whole argument is intrinsically the nature of this tunnel is such that it's going to potentially cause danger to pedestrians. That's your case.
Yes,
it will.
And an inspector couldn't reasonably hold otherwise.
yes.
Well, Sir Patrick has summed up your case very well. Now, I think we probably just about covered the ground. Is there anything that you, any topic which you feel we haven't?
Yeah. Well, there was this other point about the British Horse Society guidelines. There's been a subsequent guidelines which is amended, which we seek to rely on, which the new guidelines deletes the reference to the 2 meters height. They say the new guidelines state that page 25 of the core bundle. Underpasses. While the Society seeks a desirable height and width for underpasses, in exceptional circumstances, a lower height or width may be tolerated for a crossing of a road or railway which be unsafe to cross at a grade and where there is no option to increase the height, as such as where the water table is high. When a lower height for an underpass is locally agreed as acceptable, equestrians would be expected to dismount, although those with smaller horses and lower vehicles may choose not to if they are comfortable with the clearance. Where a lower height is acceptable as unavoidable, a mounting block should be provided at either end for those who are forced to dismount.
This is remarkably like the one you showed us at supplementary page 142, except that the ideal height has gone.
That's been deleted.
Yes.
And of course, we raised this because the judge made a point of the 2.0 the 2 meters in his decision. And of course, the other point here is it says it's where the society has agreed. Now, there hasn't been any agreement with the Horse Society that there's exceptional circumstances, and the judge didn't make that caveat because the way he put it was that, it's the British Horse Society say minimum is 2 meters, and he's disregarded the caveat that it should be agreed with the British Horse Society, and there should be mounting blocks. But these guidelines have come out after that hearing, and we think it's important because of the safety considerations that it should be taken into account now.
Yes. Right.
Right. Yes. So turning now to Sheringham in page 53, the judge was able reasonably to find that this was not a case that was comparable on its facts to Sheringham. Well, we think that's an unreasonable finding. The in Sheringham, there was no evidence of injury. People had to step out of the way for passing vehicles, and it seems to me on all fours with our present case. And also in the case of Thornhill and Weeks, in page 50, paragraph 54 at page 58. The judge says, I do not find any assistance in Thornhill and Weeks. Well, he's just stating that the facts are different, but the important point in the case was that the comment that the lady owner would not have wanted to dedicate, could not be taken to dedicate with the route going right by her window. So that was the principle of law in Thornhill about the nature of the locality. The judge, which is applicable I would say in our case, was completely ignored. It's just been distinguished on the facts. Well, it wasn't a farmyard, but we weren't saying it was. And we then go on to state that Yetkin in Mould was of no assistance. We had referred to this case before the inspector, but he didn't deal with it. In paragraph 52, he said, the objectors have also referred to the issue of safety when making submissions on the physical character of the route and statutory incompatibility. In terms of he again deals with statutory incompatibility, but no discussion at all about the physical character of the route, which we set out in our submissions to Mr. Yates. To say that it's a negligence case, we think is insufficient. Neither the inspector nor the judge really looked at anything beyond public nuisance. The character of the way or the location can prevent an implied dedication, and that's referred to, of course, in section 31, the statutory, which specifically refers to where common law dedication cannot happen because of the character of the way. Now, we were saying that in Yetkin, that case found that the highway authority or any person has a duty recognised at common law not to create a hazard on the highway which would affect the safety of road users. And in that case, it was found. It was alleged that the highway authority had created a danger that it did not have to be shown that the danger amounted to an enticement or that the claimant had been trapped into danger, that when the authority planted shrubs which grew so large as to obscure the claimant's view from the crossing, it negligently exercised its power in breach of its duty to the claimant. Now, with the layout of the tunnel, the Wisley end of it is higher than the northern end. The measurements are set out in the document we referred to earlier, which were measured by Mr. Williams. So that anyone, you may, on the approach from Wisley into the tunnel on a horse, one may think, oh, well, with that height, that would be high enough to go through. But of course it narrows as you go towards Byfleet, and that's a trap and a danger. And we think that because of the physical nature of that tunnel, that was a dangerous situation, and that the Department of Transport couldn't be deemed to have granted bridleway rights in such a situation. And that also ties in with what we were saying earlier, that the intrinsic nature of the subway with that meter meant that it just, because of its very nature, bridleway rights could not be granted over it. There's a further point on that with common law dedication, that the burden of proof on showing an intention is on those who claim the route. We think that Yetkin was an important matter, and just to say it's a negligence case doesn't really consider that, and the rest of the arguments over the physical character of the way should have been taken into account. If the way is, if the land is such that you cannot.
Well, Mr. Garland, you're going over the same ground,
right?
Aren't you? It all comes back to the same essential point. You're saying they had no capacity to dedicate because intrinsically it was creating a public nuisance.
Right. And that the inspector and the judge didn't make reasonable decisions on that or give reasons for it.
Yeah. Yes.
I think the only further point which I need to make is on the likelihood of nuisance. The way
I think you say that may not have been many horses in the past, but there'll be a lot more in the future if the Woodruff's stables use this as a route, and so that will increase the risk. You say.
Well, yeah. The cycle use And the slight horse use gives rise to a presumption, doesn't it? So then you're looking at, was there an intention to dedicate?
Sorry, say that again.
The use by cyclists and of the horses gives rise to a presumption of an intention to dedicate, and you then have to look at what the intention of the landowner was. Can you presume at common law that the Department of Transport would have granted that? And that's why we're saying that the cycle use, if you take a case where there had been no horse use at all, there was only cycle use, and there was going to be a bridleway. Well, the cycleway use would have created a presumption. You would then have to look at the intention of the landowner. Would he have? You then have to say, did he have an intention to create a bridleway? Did he intend cycles and horses to use it? And then you have to decide whether the creating of permitting horse use, would that be a public nuisance? Well, if there hadn't been any horse use, you might not know, but you have to consider whether it would be. It would, just to say that you just look at the existing use, from the principle surely must be that you have to look at the situation, decide whether there was a nuisance. We've referred to the woodruffs and that. Well, of course it's relevant. If you've had signs up saying no horses, as we had, on the start of Footpath 3 and between points C and D, Surrey County Council, no horse signs. I'm not going over the grounds that these weren't an interference. I'm merely saying that would discourage people from using it. And in fact, the sign on Footpath 3 is still there. The Surrey County Council, obviously in 1999, had some reason for putting the no horse signs there.
I thought you were heading for a different point, which was the legal point as to whether or not it was sufficient to show a risk of public nuisance, or whether you had to show public actual. Were you heading for that point?
Yeah. Well, if there has been no, you still have to.
I thought you were heading for the legal point rather than the evidential point.
Well,
because your case is that it's sufficient if you show a risk of public nuisance.
Well, this is what the guidelines say. That you have to determine whether the landowner had an intention to dedicate. And to do that, you have to decide if the granting of a bridleway would be a public nuisance. Well, if there has been no prior horse use, you have to then delve out, well, would it be? Because you could have a situation where cycle use was perfectly acceptable, but for some reason it would be dangerous for horses, and if no horses ever used it, then the granting of the rights creates the public nuisance.
You can't grant it anyway. You can't.
See, if you look at Hereford and Worcester and Pick, in that case there was a complaint that motorcyclists and cyclists would cut across the footpath at right angles, and that was dangerous. And it was decided there that it was dangerous, and a barrier had been put up, and that was found to be de minimis obstruction. So there was the decision was taken there on the facts about it being whether motorcycle use on there was danger. There wasn't, from the report, there was no evidence of near misses or whatever. It was just that cyclists or motorcyclists using that path was dangerous. And I'm asking you to say the same thing, that horse use at this point would be dangerous. No, if that means speculating about what the future situation is, yes. Right, okay. Well, I think that's covered the points which I wish to raise.
Good. Has Mr. Salaman prompted you to make any other points?
No.
Obviously, we don't want a second speech, but I think we've covered the ground pretty well. Good. Thank you. Thank you very much. Mr. Westaway.
Thank you. I hope that in my skeleton argument I have addressed all of the points that were raised in writing. So I just want to address some of the points and particularly pick up on some factual points or other updates. If I can start with just 2 points of background context. The first is this track, referred to often as Muddy Lane, when it goes under the M25, is a track that was designed to be capable of carrying vehicles, vans, as was clarified. I think what's happened is it doesn't do that anymore, but that's within its specification.
This was Thames Water. Yes.
It's at least Thames Water. There's reference to various others, and there's also reference to it being used, perhaps very well creating a public nuisance, but by motorcycles and vehicles and fly tippers in the past. So it has that within its specification. We're not talking here about a narrow footpath. We're talking about Muddy Lane, which is a track. It is, on its lower level, 5 metres. The usable width of that, again, may have varied, but it's got 5 metres across. And if one turns one's mind to the countryside and public use, whether it's on horses or on foot, of public rights of way, it's extremely common to find places in the countryside where one may have to squeeze through somewhere or stoop to use what may be a very well-established public footpath. The fallacy in my submission behind the appellant's reliance upon all of these design standards is they're really aimed at the wrong thing. The question for the inspector in this case was not, you are designing a new underpass for pedestrians and equestrians and private vehicles, whatever it might be. What height should that be? The question was, based upon the evidence before you of past use of this underpass, can you infer that the landowner dedicated that route to the public? And that's based upon the quantity and the quality of that past use.
Past use by cyclists or horse riders not by pedestrians on foot.
The pedestrians on foot becomes relevant, and I'll come to this as needed, but pedestrians on foot becomes relevant because of a capacity argument. And it's very clear that that's what public nuisance is a species of. It's a species of the argument that the landowner does not have the ability to dedicate to the public use of a right-of-way if that use would constitute a public nuisance to other users of the right-of-way. And there's two parts of that. It could be obstruction, or, as I think is pretty clear in this case, it's the danger side of it. So it's whether the use endangers the health, property, or comfort of the public. And another point, perhaps to note in introduction, is when one's looking at these kind of capacity arguments, I'll perhaps just deal with it now, it's very clear the burden is upon the party seeking to show that there's no capacity. And I cover that in my skeleton, but just getting it out of the way, the two references I have for that are Hallsbury's Laws, that's tab 20 of the Authorities Bundle at para 145, that's Hallsbury's Laws on highways. Tab 20 is the second page in, I hope. And I hope these bundles, we did slightly change them, so I hope these bundles are all in the right order.
Yeah.
So it's under the heading Capacity to Dedicate, and it's the second sentence in I draw attention to on the burden of proof.
Yes, but doesn't seems a bit circular. Where a prima facie case is proved of an intention to dedicate, then the burden shifts.
The burden shifts to show that the landowner may not have been able to dedicate. I can understand why it might seem circular. I don't think it is circular if, my lord, one bears in mind that to establish the inference of dedication in the first place, you have to have shown, as the inspector found in this case, some pretty clear evidence of open trespassery or not permitted and not by force use over a considerable period of time. So the use comes first, then it's what you infer from that, and then if a party makes arguments to say, well, actually there's no capacity to dedicate here, whether it's statutory incompatibility or a public nuisance argument, the burden's upon them to show that. I think I'll just
So in applying that to Sheringham, there was ample evidence of use by the carts over many years, and I think in the judgment or in the report it's referred to as a constant flow. So that creates the prima facie case, and then it's for the defendant to say, but this constitutes a public nuisance and therefore there can't be an intention to dedicate.
Yes.
Have I got that right?
And in Sheringham, I think the evidence was very clear, at least as the judge found it in that
Well,
case.
you don't have to be a rocket scientist or even a chancery judge to work out that if wheeled traffic, a cart, is allowed to go down a lane which is at its narrowest point is only 4 foot 4 inches wide, that creates a danger to the public.
But the facts of Sheringham were much stronger than that, because they showed that it was effectively permanent traffic in both ways. So you had a permanent traffic of carts with permanent,
even worse,
with pedestrians having to stand out of the way all the time, effectively all the time.
So, I mean, I've no doubt that there can be an overlap between the two, and it might be that if use were simply so constrained, that might give rise to other problems that would make the use not as of right. It might be that it would cause problems with the landowner, for example. The reason why there isn't circularity here is because in the first instance you're looking at the relationship between the user and the landowner to see what the landowner intended. The second question is, could the landowner possibly have intended something that impacts upon pedestrians? I think I can just give you the other reference, apart from Hallsbury, to the same point, is it's actually from the British Transport Commission case, but it's cited in Ramblers Association, recent-ish decision of Mr. Justice Dove.
Sorry, just before you leave that,
Yeah.
just for my own understanding of this, at para 146 of Hallsbury, it says the Crown may dedicate to the public a right of way over Crown land. But I thought in this case that in relation to the statutory right of way, one of the reasons why the judge said there couldn't be any, at least in relation to the underpass, was because the Ministry of Transport owned the land and the Crown couldn't dedicate it. But have I misunderstood that?
No, that's correct. I think that Hallsbury is referring to the common law dedication.
Only common law. Oh, right.
The reason why section 31, which is a statutory provision, didn't apply in this
Now, I
case.
appreciate it was different, but we're only talking about common law dedication in this section of Hallsbury.
That's my understanding.
Yes, okay. Thank you. Sorry to.
But there is, I mean, just to complete the thought, I mean, there is a statutory provision in the Highways Act itself that effectively provides that it doesn't apply against the Crown. So that's why that works.
Right.
There's no in the common law, of course, doesn't work like that.
Yes, now you're taking us to Mr. Justice Dove, Ramblers Association.
It's tab 16, and it's in para 30 of the judgment. It's really his quote from Lord Heath in the British Transport Commission case. Within that quote, it's over the page, just above para 31, and it's the top two lines.
All right, yes.
And
Thank you.
the reason I draw attention to it is it, in terms of the inspector's reasoning, it makes some extra sense of it as to why the inspector expresses himself in terms of the appellants have not shown this. There's a bit more to, of course, to what the inspector says, but I think it's important context. My lords, I wasn't clear whether there still is an application for permission to rely upon new evidence. I have to confess, I don't see the 2020 British Horse Society guidance as adding anything to the issue, which is in the first instance, the lawfulness of the inspector's decision, which predated it, and indeed the High Court's decision, which predated it. So formally, I don't think the court should be admitting that document because it has no real bearing on the issues. But
Well, we've looked at it.
yeah, I don't
Speaking-
object to the court
Speaking
looking
for
at it.
myself, without consulting my colleagues, I can't see that the differences between the 1993 version and the 2020 version are going to make any difference. So that we probably need not spend too much time and energy on whether the document is admissible. We've looked at it, but if Mr. Garland's points are right, they're right based on the 1993 edition before one even gets to 2020.
Well, it was the 93 edition that was before the inspector, and he had that, and he refers to it indeed. He had that and other guidance before him. And there was one point I wanted to draw attention to, which I think, as your lordship observes, there isn't much difference between them. The 1993 version is it 1993? It might be 2016 actually. 2016 version.
Is it? Oh dear. Right. Well, anyway, the one that was before the inspector and the first one that Mr. Garland showed us.
It's supplementary bundle, page 138. So it's tab 47 if you have those. 138.
Yes.
And this stands in a way for the point that can be made about all of this, guidance or advice, and this is, as the inspector rightly noted, it's prospective advice. There's 2 points really on it, one of which I make in my skeleton argument, and the judge makes as well, and we make below, which is on its own terms. This advice, and this is on page 142, does not say there's an underpass of 2.3 metres at its lowest and higher at either end, which is, I understand, the position here, cannot be used by horse riders. It says at the bottom of the main paragraph under underpasses, or the first paragraph under underpasses, the absolute minimum would be 2 metres. And it's correct to observe that it's talking there about exceptional circumstances and what may be tolerated. Clearly this is prospective guidance. It's talking about a situation where horse riders may want to avoid other issues as to safety on the roads. And I think perhaps the reality of being a horse rider is there's plenty of hazards when one rides around in the countryside, and many of those will actually come from vehicles on the roads. But this simply doesn't support the argument that even on its own terms as prospective guidance, there's any necessary minimum that's causing a public nuisance, which is what the...
You say this goes to safety, essentially. Safety and care of the horses.
Goes to safety and care of the horses, and even on those terms, it doesn't say that it's necessarily unsafe or shows a complete disregard of any care to ride a horse through a 2 metre high underpass.
But at least in theory, it has a consequential effect, because if a horse goes out of control or is not properly under control, at least in theory, that could increase a risk to pedestrians who happen to be using the subway at the same time.
Entirely accept that. And I mean, there obviously was a discussion of this guidance and of these issues before the inspector.
Yes.
That's why one has the evidence of Mr. Williams saying that in his view that it might be normal for an equestrian to dismount and to lead the horse through. But clearly there was a discussion to that effect before the inspector. The other point to make on this guidance itself is if your lordships turn back to page 139, it's just the page before, a distinction is made in the guidance between modification orders, diversion orders and creation orders. And that must be an appropriate distinction, because where one's looking at a diversion order or a creation order, one's looking at something that's essentially new, and there may well be constraints on what can be provided, but it's open to the order-making authority to require a certain headroom, a certain width, a certain surface. Modification orders are different, and this is obviously a case of modification orders. If your lordship just read what it says under in modification orders.
Not starting with the society will object.
Yeah.
And the point there is, it links really to a point that I make in my skeleton argument, is that when you're looking at definitive map modification orders, you're looking at what the evidence shows. The evidence in this case obviously isn't going to show a greater height than the height that's available. But one's not applying these safety standards in the same way. So they have, at best, peripheral application.
Would the British Horse Society have been a consultee on this?
Yes, they were, my lord. They didn't reply.
They wouldn't say it was safe.
Okay.
Yeah, I think it is normal for all of those amenity organisations to be consulted.
Yeah. It's set out in the committee documents which are on the file.
Thank you, Mr. Garland. Yes, Mr. Westaway.
So I want to come on to just that point about public nuisance and why public nuisance is of relevance in this context. The definition of public nuisance, I don't think I particularly need to go to. It's in the case of Rimington that you have in the authorities, but it's also set out in Archbold, which was more or less approved in Rimington. The reference in Rimington is paras 10 and 36 for a note. But it creates, unusually, a criminal offence and a tort, and they're in identical terms, where something is done that endangers the life, health, property or comfort of the public. So in principle, it's correct that a creation of a danger to the public on a right-of-way can comprise a public nuisance.
Do you say that the last sentence of paragraph 36 is part of the ratio of the case? That's where the substantial section of the public phrase comes from.
Sorry, where are we looking?
Rimington, tab 11, Lord Bingham, paragraph 36. A legal advisor asked to give his opinion in advance would ascertain whether the act or omission contemplated was likely to inflict significant injury on a substantial section of the public exercising their ordinary rights as such. If so, an obvious risk of causing a public nuisance would be apparent, if not.
Yes, I do. It's much of the discussion in Rimington is about what's called the common injury principle, and that's really an expression of it. Common injury principle. So a danger has to pass that threshold. It has to be a danger to that significant section of the public. It is a high threshold.
And if you don't establish that particular element, then you still have, in the law of tort, the ability to bring a claim in negligence if injury is caused.
Negligence. I mean, I think the Yetkin case is a negligence case.
Yes.
It's always possible to attempt to bring a claim in negligence. Yeah. Indeed, in Yetkin, there was a measure of success. So perhaps speculate a little, but if there were, as the appellants fear, to be a great abundance of horse riders coming down to this way, and that were to be managed poorly by the local authority, it might be that there could be negligence cases if there were injuries caused.
But there might be negligence cases against the authority. There might also be a negligence case against an individual horse rider. There's just one thing that's slightly bugging me. Is there substance in the point that if you're looking to see whether a dedication will give rise to a public nuisance, past use may not be a reliable indicator of future use, because by this is Mr. Garland's point. I'm sorry, can I just finish? This is Mr. Garland's point that there were obstructions to horses in the past, and indeed to cycles, and that therefore, even if one had done a survey of the route and the use of the route, it wouldn't necessarily or probably be useful guidance for the future.
In principle, no. On particular facts, anything can happen. Use of a route could increase, it could decrease for all sorts of reasons. The reason I say in principle no is because the law of prescription operates by assuming symmetry. Symmetry between the use relied upon to establish the right and the use under that right once it's been established.
Sorry, I'm not sure I follow that. Why is that important here?
My Lord, Lord Justice Stuart-Smith's question, as I understood it, and I hope I didn't completely misunderstand it, is the relevance of the past use and the potential that future use might increase. And in my submission, the focus should be on the level of past use. It's that from which one infers dedication. It's a correct observation that once a route's been dedicated, and this could happen in all sorts of scenarios, the balance of user might change very considerably. That's happened as a matter of observation across the country with motor traffic, because the balance of user has changed very dramatically, and no doubt it will change again in future. But in principle, the way the law operates is to provide for dedication on the basis of past use and accept, therefore, that there'll be a symmetry for future use. It's quite clearly seen in the village green context.
What do you mean by symmetry?
It'll be the same in the future as it has been in the past.
There's on the facts of this case, there was no evidence before the inspector that there was any real chance of use changing dramatically, even if that might have been relevant. But but the proper focus was on that past use.
But there's evidence that Mrs. Woodruff wants to use it.
Well, there's evidence that Miss Woodruff did use it. There's evidence that she wants to use it. She explains why she did use it as well. One needs to read what she says fully and not just pick out one sentence. Miss Woodruff did use it, and she'd like to continue using it. Indeed, she's undoubtedly one of the very few horse riders that use this route. Because she's got a livery nearby, that would be why. So one might expect her to continue using it. One might expect a few other people to continue using it. Just coming back to the symmetry point, because I can understand why it might seem a little counterintuitive. Coming back to the symmetry point, the reason why the law assumes a symmetry is in part because of the subsisting rights of the landowner. So a landowner who perhaps drives sheep over a way and has done that could be expected to continue driving those sheep over the way after it's been dedicated as a right of way. So that's I think the legal reason why one speaks of symmetry. It perhaps doesn't matter a huge amount once one accepts that which in my submission the court should accept, that the focus is on the use that establishes the inferred dedication in here 1983 to 1999.
I can see the logic, in a sense, might be this, that what we're testing when we talk about public uses is, in substance, the capacity of the owner to dedicate. And if the owner dedicates on a use which doesn't give rise to public uses, in other words, if at that time the use which creates or establishes the dedication, if that's not at the time giving rise to a public nuisance, then one can see that there's no reason to suppose that there's no capacity at that time. But I wonder whether all this is a bit of a red herring, really. I mean, what we're talking here about, at least, is what happens when a horse goes through this particular tunnel. And whether it's 10 horses or 2 horses or 1 horse seems to me not to be very, very important. In other words, if the use increases, that might increase the likelihood of something happening. But in principle, if it's intrinsically dangerous to a section of the public, I don't see how we would be in a position to say, well, it's dangerous to a section of the public if 5 horses go through a day or 10, but not if 2 do. I'm not quite sure how one deals with that.
I think the balance of use is relevant because ultimately public nuisance is a question of fact.
Yeah.
And it arose as a question of fact for the inspector. So part of that factual matrix is who is using this route, and are there instances where pedestrians are sufficiently endangered by horse riders that it constitutes a public nuisance?
Yes.
And in my submission, there simply are not, were not, on the evidence before the inspector. The appellants perhaps tellingly draw attention to letters that don't even seem to refer to the subway. And part of the reason for that may be that there was limited use by horse riders. Clearly there was some use by horse riders because the inspector relied upon it. Indeed, that's why he engages with this question at all, and why there was the discussion before him about the suitability of the way for horse riders. But given the paucity of evidence of any actual danger, that is, in my submission, relevant, and part of that is the quantity of use. It's possible, if this were a different case altogether with Grand National horses running through, that the inspector would have to say, I'm going to discount that use, because you can't rely upon that. The inspector's relying in this case upon what he explains is a small amount, relatively, of horse riding use and a very large amount of use by cyclists. And it's important that this focus on horse riders isn't lost. Doesn't cause us to lose the larger part of the reasoning behind this order having been made, which is that there was very considerable use by cyclists that no one had objected to over a considerable period of time, plus a limited amount of use by horse riders.
But you're not saying that there has to be evidence that there has been public nuisance. You're saying that that might be very cogent evidence to show that intrinsically it creates public nuisance. But nonetheless, it may be that there's been no incident in the past that a court or an inspector could quite properly say, well, this intrinsically is likely to cause public nuisance.
I entirely accept that, and there's some of that in the Sheringham case. I mean, I think Sheringham's a bit more than that. But I entirely accept that the inspector could come to the view that the horse riding use is so intrinsically dangerous that any horse using this way would have caused a danger to pedestrians, and that would have constituted a public nuisance. The consequence of that would have been that the inspector would have then, in my submission, had to discount the horse use from his calculation, which he didn't do.
Sorry, what do you mean discount?
Well, you can't rely upon it because there was no capacity to dedicate for horse use.
But is it the position, I put this question to Mr. Garland, and I put it to you, that if it would be a public nuisance to ride a horse through the subway, then it cannot be lawful to make it a bridle way, because the law doesn't have a category of use by cyclists but not by horses.
The law, in my submission, if there's use by cyclists and cyclists alone, this is the authority of Whitworth, which it may be useful to just go to. That could justify dedication as a bridle way. So Whitworth is at tab 12. And here it was somewhat the other way round. There was more evidence of use by equestrians and less by cyclists. And what had happened was that the route had been, one could see at para 1 in the judgment of Lord Justice Carnworth, as he was, the definitive map modification in that order was to a restricted byway. The reason why the challenge was successful in the Court of Appeal was that Lord Justice Carnworth said one shouldn't infer more than one needs to from use, because under Section 30 of the Countryside Act 1968, bicycles have a right to use bridleways. One shouldn't go further and say that way is therefore dedicated.
But is this answering my Lord's question? I mean, is it the case that if on the basis of cycling use alone, something is reclassified as a bridleway as opposed to a footpath, that a horse from thereafter would be allowed to use that? I mean, that's, I think, my Lord's question.
If that was the question, I complicated it excessively.
No, it wasn't.
My answer.
No, the question was the opposite. As, Mr. Garland and Mr. Salaman, as I understand it, I hope I'm not parodying their case, they're not really bothered about the horses, they're bothered about the cyclists. But they say that the law cannot give cyclists the right to cycle past the end of their garden because part of the route includes the subway, and the subway is not safe for pedestrians to use if horses are using it at the same time. Therefore, it cannot be a bridleway. Therefore, cyclists can't use any part of the route. I think that's the case against you. And I'm not asking in this question, has it been shown there is a public nuisance? What I'm asking is, if it was shown that there is or would be a public nuisance because of horses, would that defeat the use of the designation as a bridleway?
Not in my submission necessarily. It would depend upon the inspector looking at the cycling use alone, the fact that he's made those findings about public nuisance and horse use and the implications of that, and then coming to a view as to whether dedication as a bridleway could be sustained in any event. To put the position in stark terms, following Whitworth, in my submission, if a route may not be a right-of-way at all, is used considerably for a long period of time by bicycles, no horse use at all, that will potentially create a case for its dedication as a bridleway. And the reason for that is because otherwise one's dedicating it as a restricted byway, which is too much. So the law operates in this fashion, that carriages, which is what bicycles are, aren't given the same status as ordinary cars or motor vehicles in terms of prescriptive rights. They can only go as far as bridleways. A consequence of that is that horse riders, by law, could then proceed to ride up and down routes that weren't created by any horse riders.
I'm sorry, that's the point, though, isn't it? I mean, so a bridleway does permit horses to use it. There's no concept of a bridleway on which horses cannot go, as I understand it.
There is, that's what a bridleway does. A bridleway is in a hierarchy of routes.
I mean, putting it simply, if the claimants were to succeed, we would quash this and there would be no bridleway for the moment. And if there were no bridleway, no cycles could go on that path, because they'd have no right to go on it, because it would still be a footpath. And if you're right, that if you can have some form of path which enables only people and bikes, I'm not quite sure that there is such a concept, but that would require a separate application to have that form of modification of the plan, wouldn't it?
So let me, not entirely correct, but there are distinctions here, and in a way this is a bit of an academic discussion because horse riding, albeit a limited amount, was in play in this case. There are three essential types of right of way. Footpaths, the lowest one, and once it's a higher rights in bridleways. Bridleways encompass footpath use. So
yes.
Then one goes higher again to byways. Traditionally, what are called byways open to all traffic, now restricted byways. They encompass horse riding use and footpath use. So you can always walk down a road. You can always ride down a road. The road may, of course, not actually have the headroom. So it's very possible to create a way that might give a legal right for horses to proceed down it that doesn't actually, for some reason, physically allow horses to proceed
I understand
down it.
that, but it's the legal position that we're focusing on.
Yeah. So it would be possible, I'm not saying it's likely to be a common occurrence, but it would be possible for a way to be created through bicycle use that gave the legal right for horses to use it, but they never have done, and if they tried to do it, would find it tremendously inconvenient. As a matter of law, that's possible. And in my submission, when the inspector, perhaps more particularly the judge, refers to potential management, the kind of things that one could do when managing a way is to have a road traffic regulation order that would somehow control this balance of use. But in reality, and this goes back to the symmetry point, it's likely that if a bridleway were simply created through cycle use, it would probably only be used by cycles.
Yes, but you're giving us the in this case, I'm sorry to ask again, but I want to know, it's quite important. If this application were to succeed on the ground that the horses create a risk of public nuisance or create a public nuisance, that means that we'd have to quash the order, the modification order. We wouldn't be in a position where we could say, well, we're going to do it so we allow cycles to go, but not horses. The bridleway would go as a status, and if the bridleway goes, as I understand it, until something else is done at least, cycles couldn't go down it either.
We're not at the stage of talking about what relief might be appropriate if the claim succeeds, but in my submission, the appropriate order, because the inspector had regard to, and material regard to, bridleway use, he did refer to that. If he got that wrong, then I, subject to confirming it on instructions, I can't imagine that I would resist the quashing of this decision.
In which case it goes back to being a footpath.
What would happen then is that the decision would go back to the inspector to decide what to do, but it wouldn't be inconceivable, based upon the discussion that we've just had, that the inspector could say, well, just on the bicycle use, this should be a bridleway, but that's not this case because the inspector did place material weight on.
But I'm sorry, you keep saying this, but is that something he can do as a matter of law? Is it open to an inspector? Or indeed, is there a legal concept of bridleway which excludes horses?
No.
There's, in my submission, the consequence, and it's para 42 of Whitworth that you've got in tab 12, the consequence of the analysis in Whitworth is a clear yes. There can be, I'm saying it like common or even probable, a category of bridleway which doesn't legally exclude horse riders, but may practically not be able to accommodate horse riders.
Well, I understand. Anyway, I do understand the idea that sometimes only bikes can go down it. You still call it a bridleway, though no horses in practice can go down it. Though if a horse tried to go down it, no one could say it's unlawful for that horse to be on it.
No one could say that, subject to management measures that may or may not be taken by the local authority, which are common enough. It's very common, for example, for there to be byways in this country that on their terms allow for motorbikes and four-wheel vehicles to go down them, but there to be traffic regulation orders stopping that, among other things, on grounds of danger or ecology or whatever it might be. So if a problem arose, it could be managed. But in the first instance, yes, that's correct. It would be possible to have a bridleway created that could not physically be used by horse riders, as long as it could be used by cycles.
Well, yes, of course, but is it possible to create a bridleway which gives the legal right to cyclists to pedal along it, but does not give a legal right of horse riders.
No, it doesn't exist.
No.
So, which is why you say that if we were to quash and if this were to go back, the inspector might come up with saying, this, in all other respects, evinces the intention to dedicate as a bridleway, but there is a problem, and therefore this order should not be confirmed without an additional step being taken in the terms of management orders which prevent the use of the path for horses. Have I understood it correctly?
Yes, except that in reality, management measures are entirely separate.
I understand, but legally and probably separately. But if he can't do that, there's no way through for a local authority which wishes or to have a bridleway that excludes horses.
If a local authority is faced with a way that provides right for horses, and horse riders attempt to use this way and it's positively dangerous or problematic for some reason, then the correct route for that authority is to use traffic regulation powers under the Road Traffic Regulation Act 1984, and under that they can have enormously broad powers. They could simply provide that equestrians cannot use that route. I expect, without knowing, I suspect there are such use of traffic regulation order powers on roads where there's low heights. I don't know. There's certainly plenty on countryside byways that prevent use by motorcycles. That process, though, the inspector himself, if it went back to this inspector or another one, the inspector themselves would not be able to direct the highways authority as to how they.
That seems to me a fundamental problem, because if it went back to the inspector and the question was simply, can one modify the map, as it were, to call it a bridleway, his answer would have to be no. Because on the assumption that horses are creating a public nuisance. Because he couldn't say yes on the basis that some other organisation, some other body later would have management controls which would stop the horses in practice using it.
I mean, I can see that the matter would have to go back to the inspector. I can see it might not be easy questions for him to answer. He would clearly have to have regard to the fact that the landowner did not have capacity to dedicate the way to horse riders, and the consequence of that, without making any concessions here, the consequence of that might well be that he thinks, well, I can't make or won't make this order.
He got no capacity to do it.
The whole thing would have to start again, wouldn't it? I've got another question. Suppose that Mr. Garland and Mr. Salaman are right about the subway. Could an order lawfully be made saying that whether by combination of highway powers and traffic management powers, to say that this can be used as a bridleway, the whole of the route, including the route going past the appellant's home, the whole of the route in the open air can be used by cyclists, horses alike, but horses must be taken through the subway. The riders must dismount going through the subway. Would that be a lawful form of order? I'm not asking whether it's a good idea on the facts of this case, but is it a lawful order?
I noticed the hour, and I can check. It would be there's very broad powers in the Road Traffic Regulation Act 1984. So my instinctive answer would be yes, that would come within those powers. But I can certainly have a look and come to a better informed view after an adjournment.
Sounds odd that road traffic acts can regulate horses, but maybe they can.
Yeah. Could you possibly, either this afternoon or subsequently, because this principle of symmetry that you've referred to is something which is entirely new to me. Could you give us a reference in Hallsbury's or something like that? So I can just begin to understand it.
Yeah, as I say, I mean, I don't want to get distracted down too many jurisprudential cul-de-sacs.
Why not? They're interesting.
But the symmetry, I think that in the material that's before the court, the best discussion of it is in a recent case about village greens. The village greens have some shared features with highways in that use is based upon the establishment of rights is based upon past use. And within that case...
I'm sorry, I didn't quite hear which case you're on.
TW Logistics. It's tab 17 of the authorities bundle.
Yes, thank you.
And it's head note point 1. And the discussion, which is extensive, is from paragraph 44 and onwards.
Thank you.
Right, well, how time flies. Shall we resume at 2:15?
Is the restaurant open? No. There's nothing, is there?